Now we're going to shift gears and talk about strict liability, which is very different than intentional torts or negligence. With strict liability, we look at a situation where there's something very dangerous going on. Usually we're talking about very dangerous animals or explosives or fireworks, of something along those lines. And there's really no good way to completely protect everyone from any kind of harm that could occur. So we say that the person who engages in these activities is liable no matter what. They are strictly liable for any harm that occurs because of their use of the fireworks or the explosives, or if they are keeping dangerous animals. And when I say dangerous animals, I'm talking about lions and tigers and bears. Probably the most common one is snakes. Lots of people have a big exotic snake, and if anything happens because of that snake, they're going to be liable. Even if they exercise all the care in the world, everything was done perfectly, they are still going to be liable. Probably one of the best stories out of Columbus we have is from a few years ago. There was a man who kept lots of exotic animals. He had lions, bears, tigers, all kinds of animals. He kept them on his property near Zanesville, and he actually one day decided he was going to kill himself, and he released all of the animals, and then he committed suicide. So people were driving down 70 and saw this sign, "Caution, exotic animals." There were animals running all over Zanesville. Very dangerous animals. They killed some people's horses and dogs, some other pets, and so forth. But eventually, all of the exotic animals were killed by wildlife experts. So that is how they eventually had to corral them all up. They had to kill a lot of them. So in this situation, his estate, all of his assets would be used to pay anybody who was damaged by what these animals did. If your horses were killed by one of these animals, you could recover from his estate. He is strictly liable for everything that happened because these are very exotic animals. By the same token, if you like to set off fireworks on the 4th of July, be aware that if anything happens, regardless of how careful you were, you will be liable for any harm. So even if it's not harm to you, might be to somebody else. Let's say a little spark goes off and lights a fire somewhere, or burns somebody's house down, or injures somebody, you will be liable for that. That is a strict liability situation. So even if you were very careful, that will not matter. A lot of people also like to ask me about dogs and what is the situation with dog bites. I usually like to ask the class what they think the rule is, and I almost always get somebody who says you get one free bite. So a lot of people think that's the rule. That is no longer the rule in Ohio. You don't get a free bite. You don't have the situation where your dog bites somebody, then you know that the dog likes to bite, and now you'll be liable for injury. If your dog bites somebody, you are liable, and in a sense, it's sort of a strict liability. We do have some exceptions in the statute. If somebody is trespassing on your property and your dog bites them, you're not liable in that situation. If somebody is teasing your dog or hurting your dog in any way and then they are bitten, you're not liable in that situation. But if your dog just happens to bite somebody, you could have liability, regardless of whether it's the first time it's ever happened or not. So you should be aware of that, that there is a little bit of a strict liability with dogs. And I know a lot of people have dogs, so it's a good thing to sort of know. All right, so that's it for strict liability. I'm going to shift gears once more, and we are going to talk about how you actually choose the lawyer that you are going to hire. So I'm going to show you this card, and I'm going to ask you to think for a minute whether you would hire this guy. I don't really know who he is. I found his card on the internet, but I want you to look at his card and tell me if that's somebody you think you might hire as a lawyer. And I usually get a lot of different answers. Some people don't like the design of his card. They think it's unprofessional. Some people I have told me they don't know why that asterisk is next to bankruptcy, but that really concerns them. And I don't know why that asterisk is there either. But if that's a concern, that's fine. I think that the main problem, the main reason that you should not hire this guy is there are just too many areas of practice on this card. He doesn't specialize in anything. He has a general practice. He also does bankruptcy and criminal and DUI, but he does contracts and estate planning. These are all very, very different areas of law, and it's very unusual that somebody would do all of these areas. You can kind of think of your doctor. You do probably have a general practitioner who can do a lot of things, but anytime you get into something special like bankruptcy or criminal, you know, like with the doctor, a lot of times they'll send you to a dermatologist or an internal specialist. They send you to somebody who specializes in a particular area. And the same is true with lawyers. So if you need somebody to do contracts, you're going to want to look for a contract lawyer. And if they do other business areas, that's okay. You want to see maybe some things that they do that are in the same vein. But contracts and criminal are completely different areas of law. That's very unusual that somebody would do both of those. So you just want to look for somebody who is a specialist in whatever area you are looking for. And the other thing I wanted to show you was this card, and you don't really need to look at all the details on their card, but if you look on the bottom, it says no fee to you unless we win. And I always like to ask the class, how can they do that? How can they not charge a fee unless they win? And the answer is that what they do is they charge a contingency fee. So a lot of times when somebody sues another person, they will hire these lawyers. And remember, this would be the person suing. So this would be the plaintiff. The plaintiff sues, they hire a lawyer, but rather than pay the lawyer in any kind of fee, the lawyer is going to take a percentage of their winnings. So they're going to evaluate the case. If they think they can win, they'll take the case, and then they are going to get some sort of percentage of whatever the plaintiff recovers in the negligence action or whatever it is. Now, this percentage is usually very high. It's usually 40 or 50%. So it's a huge number, which means if you win, you're going to lose about half of what you won to lawyers' fees. This is very common. Lots of plaintiffs' lawyers use this formula. And it's going to be upheld by the courts. There's nothing wrong with it. Now, one of the things that they will do is they will usually ask for more damages. They'll sort of increase the number that they're looking to get from the other party to help compensate for those fees. Lots of these lawyers, if they win a lot of these cases, they can do very well and become very wealthy doing this. But they have to be really good at it. And usually once they get really good, they're able to really evaluate well whether a case will win or not. So let's look at attorney fees for a minute. If you are being sued, so you are the defendant in a case, then most likely you would be required to pay some sort of hourly rate. It's going to be, $100 an hour, $200 an hour, $300 an hour. It can really get up there depending on what kind of attorney that you need. But remember, their hourly rate is covering everything, covering all of their overhead and their expenses and so forth. So they need it to be a bigger number than you might be thinking. So the hourly rate is the most common rate, and that is always what a defendant will pay. They will always pay an hourly rate. They're never going to get a contingency fee. That will only work for plaintiffs, and that's where they get a percentage. It's where the attorney gets a percentage of the amount won. So remember that that is limited to plaintiffs. So that's the second most common. We are seeing more of the fixed fee. That's the third thing I have on this slide. And that is where attorneys will say, we're just going to charge you $100,000 to take care of this deal for you, and that's just going to cover everything. So rather than having an hourly rate or a contingency fee, there's actually a fixed fee. That is not very common, but it is becoming used more and more. More and more companies are demanding some sort of fixed fee or some sort of version of that.